Hello students, your topic for today is essentials of easements. In essential of easements, there is a dominant and a servient heritage. When we talk about the dominant and the servient dominant heritage is the one in which the land for the beneficial enjoyment of which the right exists. So it is the land on which the beneficial enjoyment is taking place and the right exists. That is the dominant heritage. And the servient heritage is the land on which the liability is imposed. Both of these are necessary. The existence of both of these two properties is a must in the enjoyment of right to easement. This is because, as per the definition, it is the right exercised by the owner or the occupier of one land for enjoying the benefit of his or her land over the land of some other land person. So basically, over here, a owner or a occupier to enjoy his own land has to have access to some other land to have the benefit of his own land. Dominant and servant heritage cannot be one. Thus, the existence of two properties and that to be separate from each other is essential. Separate owners. For exercising the right of easements, owner of both of these two properties shall be different and not a single person. Next is beneficial enjoyment. The object of easements is that the dominant owner enjoys it in a way which includes express and implied benefit. So there are express and implied benefits, and the object of this easement is that the dominant owner who is enjoying is the dominant owner is having both express and implied benefits. Positive or negative. Easement can be both positive or negative. In the formal one, that is the positive one, it refers to a right through which the dominant owner does some act to exercise the right over the land of the servant owner. So he is doing some act so that he can exercise the right on the land of the servant owner. Whereas in the later one, in the negative one, it denotes an act of prevention. So there is an act of prevention to exercise the right over the land of the servant owner. So in a negative easement, the dominant owner prevents or restricts the servant owner from doing a certain act or acts. So in the first one, in the positive one, he is doing an act to enjoy his the dominant owner is doing an act to exercise the right over the servant owner, and in the negative easement, the dominant owner is preventing or restricting the servant owner from doing some act. That is the difference between the positive and negative easement. In a right of easement, an owner of dominant heritage can do an act or prevent the servant owner from doing something, but he cannot bind the servant owner to do something for him. So basically, he can do some act or he can prevent him from doing some act, but he cannot bind the servant owner to do something. He is the dominant owner is doing some act so that he can enjoy his own land, or he is preventing the servant owner from doing some act so that he can enjoy his own land, but he cannot ask the servant owner and bind the servant owner to do something for him. The easementary right exists only when two heritage are adjacent to each other. So the two heritage that should be separate, it should have different owners, should also be adjacent. It is right in rem. Right in rem means right available against the whole world. Easement as a right is always annexed to the dominant tenement. It is the right of re aliena, which means a right over a servant tenement, and no one no one one's own land. Classification of easements. When we talk about classification of easement is mentioned under section 5. So it is continuous or discontinuous. When we talk about continuous easements are the one whose enjoyment may be continued without any intervention of any human conduct or any act of the man. There is no interference by a man, and it adds special quality to the property. So there is no interference, there is no intervention, and there is a special quality added to the property. While on the other hand, in the discontinuous one, the right of easement for the enjoyment, which which an interference of a man is required is known as discontinuous. So in the discontinuous one, there is the interference of a man. In this kind of easement, it is necessary that a human act is done on a servient heritage. So human act, the interference act, the human act is done on the servient heritage. Apparent or non-apparent. An apparent easement is one the exist of which can be seen through a permanent sign. So the existence of this kind is with a permanent sign. It can be visible by a careful examination on a reasonable foresightedness, and it is also known as express easement. For example, there is a drain from A's land to B's land, and from there it led to an open yard. This can be visible through a clear inspection and is an apparent easement or a express easement. An inspection is required to check the existence of a right. Whereas in a non-apparent easement, it is just the opposite of the apparent easement. In this kind of easement, it is not visible through an inspection. There is no permanent sign. The right is in use but is not visible, and thus is known as invisible easement. Example of this is this, that A's right annexed to A's land to prevent B from building on his own house. Another example to explain non-apparent easement is that the right to stop construction over a certain height. Thank you.